I represented startups from formation all the way through M&A. And at the same time, I also did trademark work all that time. So I always look at whatever it is that I'm doing in the context of someday you're going to want to sell this business. So that's always my focus. And, you know, making sure you don't, when you sell your business, you don't get what I always call this business is a mess discount. So I am going to share my screen. I have written down like what each of you gals want to hear about. If Beth, at any time, if you want to interrupt me, because I won't be paying attention to the chat, but interrupt me, just cut right in and stop me if there's questions or anything like that. Okay, so I'm just going to be concentrating on what I'm saying and what you guys want and my screen. So let's get going. Okay, can you give me permission to share?
Sorry about that. Give me 1 second.
Okay, no worries.
You should be able to. It's not showing up at
Okay,
the bottom.
it's saying host disabled attendee screen sharing.
Oh, great. Okay, I actually need to make you a co-host.
Okay.
So, do you see it now?
Yep, perfect.
Okay, great. Thank you.
Okay. Hello, Zoom. Okay. Sorry, ladies. Sometimes Zoom like forces you to go through all these crazy iterations of life, and I don't know why. We will get to it. I promise, any second now.
Oh yeah, you're preaching to the choir.
Oh my gosh. Okay, let's try it again. Okay, we may have to do without the screen because I don't want to keep wasting all your time. Just so you know, while I'm trying to work this out, you don't need to take like crazy rapid notes. I'm going to share with Beth at the end of this, not the slides themselves, but I'm going to actually share like a written paper that I did that will actually allow you guys to, it actually has it like written out in words. So it's not just like little bullet points and things like that. So that should be really helpful. Okay, let's try this again.
And if you want, you can send it to me and I can present it.
Oh, that would be a perfect idea. Let's do that.
Yeah,
Let's
okay.
do that. Okay, hang on. Because for some reason it is not happening. Okay, hang on. Wait, we may have it. Hang on. I think it's gonna happen. Oh gosh, ladies.
No judgment, my friend. Keep going.
No judgment. Okay, we're going. We're gonna get there. Yeah, any second now. Oh my God. Okay, I'm gonna share this with Beth. Hang on a second. That way we'll have 2 ways to go. Slides and Nabo at the overview, go, sending. Okay, I'm just gonna get started. And Beth, if you get that and you can get it going up there, that'll be fine, okay? All right, so ladies, there are 4 and only 4 types of intellectual property. And we're gonna talk about all 4 of them. Sometimes things that are essential to your business are not intellectual property. And what I mean by that is that there's no way for you to get exclusive rights to that thing. That's what property means, is that somebody can have exclusive rights. Okay, so the only 4 that there are patents, and those protect rights to an invention or a design, copyright, and that protects original works of authorship, trade secrets, which protect business secrets, business information that is kept secret, and trademarks that protect your brand. That's it. They're only the four. And if you get the wrong kind, like if you try to register something as a trademark when it's really copyrightable, you don't get the right kind of protection because it doesn't give you the exclusive right to stop people from doing the thing that you're worried about them doing. So that sounds very complicated, but I promise it will make sense as we go through it. So we're going to start with patent because frankly, it's the most complicated and it is also the one people ask about the most, but frankly is the least likely to be useful to you. Okay, so let's start off with the idea that a patent is a property right that's granted to you from the US government. So you'll hear me later talk about other types of intellectual property that are the exact opposite of that. So you send an application to the US government that says, I meet these criteria, award me exclusive rights to this. Tell me that I own this and I can stop other people from using it. That's what a patent is, okay? It is the right to prevent other people from practicing the art described in the claims of a patent, okay? So what that means, that you have a patent and there's all these words that come out to a claim. And if somebody else tries to do what's in that claim, you can stop them if you have that patented. The problem, so we're going to talk about utility patents, which are what most people think of when they think of patents. The problem is that the standard for getting the government to give you that exclusive right is extremely high. Okay, so let's see, somebody talked about whether Alexis was talking about the ideas that she had for her business and what she was doing. And she kept saying, you know, other people have done things like this, but maybe the way I'm doing it is different enough. That's exactly what the issues are with getting a patent. So first of all, you can't patent an idea. Okay, you have to have more than an idea. It has to actually be something. It has to already exist in the world. So you can patent a method, a machine, manufactured articles, a chemical composition, a mixture of ingredients. Those are the kinds of things that you can patent. And it has to be has to have a useful purpose and it has to be operative. Okay, so it has to be something that somebody can actually make use of. It has to be really there and really a thing that somebody can make use of. The other two requirements is it has to be novel. So if somebody else has already did it or somebody else even just wrote about it, you can't get a patent. And it has to be non-obvious, right? So if, you know, we already have smartphones and smartphones have all these capabilities and every year, every month, they have more and more capabilities. A lot of those capabilities are not something that anybody could get a patent on because it's just obvious, right? That's like obviously the next thing. And if you were an engineer, electrical engineer or a software engineer or some other kind of engineer that regularly works on these, everybody knows that that's going to be the next thing, right? So those are the requirements, and those are very, very, very high hurdles to meet. So for example, my website, Beeline, you know, it allows me to collect all the information that I need from my clients in order to help them get a trademark registration. There's nothing patentable about that, right? TurboTax already did that for taxes. You know, it's just nothing new. I'm just using, you know, decision trees and, you know, those kinds of things, just like everybody else did. Nothing patentable about it. Somebody else could go out and do exactly what I'm doing and I couldn't stop them. But that's okay because I have other ways of protecting my business. Okay, so that's a utility patent. So I have, like, just to give you an idea of what that is. So one famous utility patent is an electromagnetic inductive suspension and stabilization system for a ground vehicle, right? We call them maglev trains, right? So there's all kinds of patents associated with somebody coming up with the idea of running a train using magnets so that it's not actually touching the ground and creating friction. an omnidirectional vertical lift helicopter drone, right? That was the original patent for the first guy who came up with the idea of the drones that we see everywhere now, right? So all of those types of things are utility patents. There's also a different kind of patent that's called a design patent. And those have no utility. But they still have to be non-obvious, and they have to be something that doesn't function. So for example, a Herman Miller chair. Do people know what I mean when I refer to a Herman Miller chair? It's the chair it's a desk chair, and it has kind of the webbing in it. And it rolls around, but it's like a very specific one. You've probably seen them like in like really expensive startup offices. They always have Herman Miller chairs, right? So the design for that, but it's a design thing. It's not because of the way that it functions. And you can't have the design patent doesn't prevent other people from putting arms on chairs or backs on chairs or wheels on chairs. It's just the very specific way that looks. Little Lego people have a design patent. There's like this weird design for like a twisty, windy, almost DNA looking thing that's the heel of a shoe. That kind of thing can be the subject of a design patent. Okay, so everybody's faces are blank. That's because we've been talking about patents and nobody understands it. Don't feel bad. 99% of the time, you're not gonna need a patent. You're not gonna want a patent. You'll see also later that patents are the most expensive thing to get and even more expensive to defend. So 99% of the time, my clients aren't looking for a patent. So wipe that all away. Now let's talk about the ones that actually are likely to matter to you. Okay, second one, so those were patents. Now we're gonna cover copyright. I think people know a little bit more about what copyright is. Copyright protects original works of authorship. So you can have a literary copyright for, say, a book that you wrote or a workbook. Somebody was talking about doing, right, Tanya was talking about that she's going to be creating a workbook and some books that are associated with her business. That is exactly the kind of thing that has copyright. It can be dramatic. So it could be a play that instead of, publishing it, you actually perform the play. It can be a piece of music. It can be the recording of a specific piece of music. It can be a piece of artwork, a sculpture or a painting, right? It can be architectural, buildings like the Flatiron, well, not anymore because it's been too long, but if you're an architect and you design a building, you own the copyright to the way that building looks, okay? So those are copyright. That kind of stuff happens all the time. A copyright is the exclusive right. You're going to keep hearing me say exclusive right, right? So the patent was an exclusive right to an invention. A copyright is the exclusive right to reproduce the copyrighted work, okay? So if it's a song, if I've written a song, nobody can sing and record that song unless they deal with me first. You can't prepare a derivative work. So if I have recorded that song, you can't use that recording to do something else with unless you check in with me and pay me money. You can't distribute copies of my copyrighted work. So you can't copy the song, you can't make a copy of the MP3 file and sell it to people without violating my rights. If it's a play, you can't perform it. If it's a choreography, you can't dance that dance in public.
Michelle, I have a question,
Yeah.
quick question.
Yep.
How about copy on websites and brochures, things
Right.
like that?
Yes, you can't make a copy of it, whether it's a physical copy or an
Okay.
electronic copy. You can't make a copy of it unless you have the rights from the person who owns the copyright, okay? And because it's display of the copyrighted work publicly, okay? So
Okay.
reproduce or
Okay.
display it, anything like that, that's what the copyright owner owns, the exclusive right to do all of those things. Okay, so remember when I said at the beginning that a patent is a right that the government grants to you, and you wondered why anybody would care? The answer is, let's talk about copyright. Copyrights aren't granted to you by the government. They exist. Okay, so when I wrote the paper that I'm going to send to Beth, or I wrote this presentation that I've now emailed to Beth, I own the copyright to, well, actually Berdinas Law PC owns the copyright to that. And we'll talk about that in a minute, right? The instant you reduce something to a tangible form, and when I say tangible, it doesn't necessarily, right, typing it on the computer now counts, but these laws were all written before we had computers, okay? The minute you reduce it to that, you have copyright, okay? And you should always put the little C in a circle and the year and the owner of the copyright. So on my stuff, you'll see when you get the paper that I'm gonna have Beth send around, it's gonna say copyright, I think I wrote that one in 2019, Berdinas Law PC. And you should put that on everything where you create something and you write it yourself. Okay, you should put that on there. You can take the further step of registering that copyright. It's not hard to do. You can do it yourself. Copyright.gov is the website. It's part of the Library of Congress. It's not that expensive. They just changed the fees. I think it might be up to $50, but it's not expensive. But it can get expensive. So like if you're a photographer, you're not going to copyright every photograph you've taken because it's going to start to add up, right? So you should pick the most important things that you have created and register the copyright to those things. For example, in my business, the only thing for which I have registered the copyright is the content of my website. That's it. When I write these papers and stuff, I don't care. If somebody shares that with somebody else, I don't care. I don't care enough. I'm never going to sue somebody over that. So what do I care? But Tanya, you might care a lot about your workbooks, right? So that would be something where you actually would consider getting a copyright registration, okay? So that's copyright. Questions on, yep, Tanya, yes.
Yeah, we had two questions about
Great.
copyrights in the chat box. So
Okay.
one is from Alexis. Should a biz copyright its EPK and websites and logos, for example? Alexis, do you want to expand on that?
What is EPK? I'm sorry, I'm spaced. What is EPK?
That's okay. Alexis, you want to take
That's
off
okay.
mute? Yeah.
So I'm right in the middle of doing rebranding. So I should be finished next week. New website, new logo, the whole 9 yards. This has been since 10 years, we haven't had any new stuff. So I was just wondering, as you spoke, I said, should we be copywriting our website? Should we be copywriting our logo?
Okay,
I don't
so
know.
the logo, and we're gonna get to trademark pretty
Okay.
soon, but that's really where the logo thing is gonna come
Gotcha.
in.
Okay.
I have copyrighted the content on my website because it's not just like a brochure, it's massive, right? It was 1,000 man hours to create my website, and it has all these decision trees, and I spent a lot of time creating it, right? And since I can't get a patent on the way that it functions, somebody else could recreate what I did, but they'd have to rewrite everything, right? So that's just a little bit of a barrier to entry. But if your website functions more as like a brochure and doesn't have, it's not that vast, it may not be the thing that you want to copyright. But the trademark thing is something we're going to talk about, and that's where we'll come back to it.
Gotcha. Thank you.
Okay. Okay. Since I'm not sharing my screen, let's see. Should a biz copy? Okay. What about webinars made in PowerPoint for other organizations? Tanya. Right. So we're going to get to this, but so are you the one making it for other people?
So yes, I'm creating the visuals, the content, and then sometimes I keep it on my template and they just have their organization slide like at the beginning and end. So there's a fine line, right? Like, do they own it then?
You own it.
It's their property?
You're an independent contractor, and we're going to talk about this very specifically because this is something everybody gets screwed up. The reason that Berdinas Law PC owns all of this stuff that I write is because I'm an employee of Berdinas Law PC. Okay, so if an employee creates something that's copyrightable, the company that they work for owns it. But if I hire Tanya to write something for me, and we don't have a written signed contract, not an oral agreement, a written signed contract that says that when she writes it and she hands it off to me, I own the copyright, she does. Okay, so when you hire somebody, to do work like that for you, you should have an independent contractor agreement. And I'm going to put my email in the chat at some point, and anybody who wants a form of NDA or a form of independent contractor agreement that I wrote, that's like not just some garbage you get off the internet. And that's specifically designed to be an incoming, right? So it's not that great to use it like if you're going to be providing independent contractor services, because it's more for the person who's receiving the services. It's slanted in that direction. Okay, so yeah, so you own those, Tanya, unless you have a written agreement that says that they do. Now, should you register that? So the answer is, if you found out that one of those companies then gave it to some other company to use, how pissed off would you be? And if the answer is very pissed off, because that company should have come back to you and bought it themselves, you should register it. If the answer is not really that pissed off at all, then don't bother to register it. Okay, let's see. Can you copyright a catalog number of works for one? Yeah, so whether you can mush everything together and only pay one fee, that's a really complicated subject, and it kind of, it's more than we can cover here today. But if somebody wants to talk about that, who's asked that? Angela. If Angela, you'd like to talk about that on, like have a call at some point and we can talk about that. But most of the time, like unless there's literally, you know, like you've created a book out of all your photographs or something like that, where they really are a collection, you can't do it with one $50 fee. People have requested the presenters to share the recorded video, wondered what the implications are for both. Yeah, so just because, like if this was being recorded and I had my slides up there, that doesn't mean I've transferred the copyright to anybody. Oh yay, here we are. Yeah, so move on to the next one, I think, actually. That would be great. Great. Okay, so yeah, so if you wanted to do that, then this doesn't, my having this up here doesn't mean I've transferred the copyright to anybody. I still own it, just because it's up here. Now, I have obviously, by agreeing to do this, I have given permission to NAVO, New York City, to do this, right? That's implicit in what I've done. But that doesn't mean that they get to use it some other way, right? They can't now, just because I sent this file to Beth and told her to throw it up on the screen, that doesn't mean that Beth can go out there and do whatever she wants with it, right? That's a different thing. I've given them permission to do this. Okay, next slide. Okay, now, so we've talked about patent and we've talked about copyright. Now we're going to talk about trade secret. Trade secrets is information that has business value and is kept secret. Trade secret. Okay, so you have to take steps to keep it secret, right? You have to share the information only on a need-to-know basis, right? So if you have 5 employees in your company and only 2 of those employees really need to know that secret in order to do their jobs, but it's just on the server where anybody can access it, it's not a trade secret because you haven't kept it, you haven't taken steps to keep it secret. Your employees usually have a duty to keep these secrets, but you should have a written agreement with them that guarantees them confidentiality. Non-employees have got to sign an NDA before they have access to that information, or it's not a secret. And you have to not leave it laying around, like I said, and that means in real life or virtually, right? So if you consider your customer contact information to be secret, but you know, there's a printed out version of it and it's like laying on your desk where like, you know, the guy who like empties the trash at night can see it, that ain't a secret. And in order to sue somebody under trade secret, you actually have to show the steps that you took to keep it secret, and you have to prove that you took them all, right? Trade secret is a hard thing to rely on. First of all, most businesses can't function without revealing the secret. right? So Beeline, I could keep like the whole idea for what I was doing for Beeline, I could keep that secret until I launched, and now it's not a secret, right? So nothing I can do about that. The other problem is that a lot of times if trade secrets get out there with the internet, once a secret is out there, it's everywhere. And you can't put the genie back in the bottle. And whoever it was that released that probably doesn't have enough money to make you whole. So trade secrets can be dangerous to rely on. Next slide, Beth. Okay, now we've covered 3 of the 4: patent, copyright, and trade secret. Now we're going to cover trademark. This is actually what most companies end up relying on. Okay, so a trademark is anything that identifies a source of goods. It can be words, it can be logos, it can be a color, right? This kind of bluish looking square here. What company is that? Anybody? That's Tiffany Blue. Yeah, that's Tiffany, right? I mean, if you saw somebody walking down the street with a little teeny shopping bag, like a little teeny bag, and it was that color, even if you didn't see the word Tiffany written on it, you know darn well what's in that bag, right? So packaging, like a Chanel bottle, right? If you couldn't read that label, you would still know that that's Chanel, right? Sounds, when you boot up your Apple computer and it goes boing, that noise, that's a registered trademark. Smells, the smell of Play-Doh is a registered trademark. So that's what a trademark is. Nancy has a question here. Hang on, what's the difference between, hang on, a trademark and a service mark? Yeah, so a trademark is for stuff, like goods, and a service mark is for services. I'm going to use the word trademark because a lot of people don't bother with the word service mark. So technically Beeline is a service mark because what I sell are services, not stuff. But if I sold jewelry like Tiffany, I'd have a trademark. Okay, next slide. Okay, so trademark is like copyright in that you get trademark rights automatically as soon as you start using a trademark to sell stuff, right? So if you create a widget and you put your brand name and you put your company, you know, the trademark on there and you start selling them, that's it, you have trademark rights. And just like copyright, you can register those rights if you want to. A trademark is the right to stop people from selling products or services in a similar industry using a similar trademark, right? You can't stop them from selling a similar product or service, right? It doesn't stop them from using your idea or from selling exactly the same thing. All you can do is stop them from using the brand to sell it. Okay, and that's why, like, in a lot of different industries, that's all you have, right? So fashion, restaurants, like services, right? I mean, all of those things, everybody sells jeans. Restaurants sell lasagna, right? You're not going to have anything in there that you can protect. It's just that I don't just want lasagna. I want lasagna from that particular restaurant. I don't just want legal services. I want Beeline legal services, right? So that's the way most people protect their businesses. Okay, next slide. Okay, so what are all the little squiggles and stuff that you always see on things, and which should you be using? So a little TM means that you have common law trademark rights. That means that you started selling a good using that brand, and so you have those rights. A little SM is common law service remark rights. If you give a service and you use the TM, it's fine. It's not that big a deal. The little R in a circle means that you've taken the additional step to register that trademark, right? So you don't have to, you have trademark rights, but if you have registered the trademark, you use the little R in a circle instead. And the little C in a circle is copyright. And again, you should use that the minute you reduce something to writing, the minute you reduce, or you paint a painting or create a sculpture, you should put that on there, and then you can register it. A registered or unregistered copyright, they still just use the C in the circle. There's no difference. Let's just confirm, should we use consultant and sign a standard form of agreement or NDA? Yes, and we are gonna talk about that. I promise, we're gonna get to that. Okay, so we've talked a lot about like sharing of idea, whether you can, an idea is protectable, which it isn't, what within your business is actually gonna be protectable. Let's move on. Go ahead, let's hit the next slide, Beth. So let's talk about the IP mistakes that people make, and that's going to introduce these concepts about like NDAs and independent contractor agreements and stuff, okay? So, as I said before, intellectual property ownership. If an employee created whatever that, right? So if the employee, drew the little logo or wrote the pamphlet or whatever it was, the company that employee works for owns it. If it was done by an independent contractor, the contractor owns it. The person that they did the work for has a license to use it, but it belongs to the contractor. And the contractor can use it again, and the contractor can do all kinds of things with it. And the company that the contractor did it for does not own it unless there is a written agreement that says that the intellectual property got transferred. So that's right. So we talked about who owns stuff, which I think was something that Beth wanted to know. Let's see. Okay, and then the other thing that people do wrong is they get the wrong kind of protection. So I don't know how many of you have been through Midway Airport. There's a company in Chicago called Nuts on Clark, and they have a little store inside Midway. And when I would be on trips with my kids, they would go, oh no, mom's gonna complain again. Because we would walk past the store and it said Nuts on Clark and a little C in a circle. It's not a copyright, that's a trademark, right? That's the name. They are selling nuts using Nuts on Clark as their brand. And what's even funnier is they actually did send that to the Copyright Office, but that doesn't protect them, right? That just protects them from me taking a pen and going Nuts on Clark. But it doesn't prevent me from, and actually you can't get a copyright to 3 words, but I can use that brand. They have trademark. Anyway, it's wrong, just that little C in a circle. And my kids used to just laugh because I could not walk past it without screaming. You also need to know whether or not you're infringing on somebody else's intellectual property. So it doesn't matter whether you know it or not. You could be infringing on somebody else's patent. If you did it and you didn't know about it, you're still infringing. You could have picked a trademark that somebody else is using in your industry. Just because you didn't know about it doesn't mean you aren't infringing. So it's important to know that. When people steal copyrighted material, and this happens all the time, they always claim that it was fair use. And I got to tell you, like, fair use it's like this big. I mean, it's this tiny little category. And I guarantee you don't fall into it. But people always say, no, it was fair use. And it isn't. So don't rely on fair use unless you've actually talked to a lawyer and you've actually decided that it is. So we already talked about picking a trademark that's weak or owned by somebody else is kind of the infringing on somebody else's property. Okay, so let's see. So yes, so if you hire a contractor to do work for you and you want to own their work product, to answer Alexis's question, you absolutely have to have a written agreement with them, an independent contractor agreement. And if you have an idea and you want to share it with people because you need their help to get that idea moving forward, and you want to maintain that as a trade secret until you launch it and the secret is out, then yes, you have to have in your independent contractor agreement, either have non-disclosure language, or if all you want to do is just disclose it and then talk about it, you can just have an NDA. And again, I'll put my contact information in the chat so that people can, I can send you stuff. Next slide. So how much does it cost? Because this is something I promised to cover. Before we move on to this, I think I've hit everybody's questions that I wrote down. Have I? If I can't see everybody's. Let's see
Michelle,
here.
I just had one question right
Yep.
now, just a quick one. So I'm paying attention to one name. I searched it. It looks like they haven't been using for the past almost 3 years. So it was an app. Now it's not working. The website is down. So it looks like it's a dead. So how do I figure out? I know it takes 3 years, and I did some reading. So I'm not sure. So how do I go about it?
If they have a registration, it's still there.
Okay.
Their registration won't die. If from the day that they got the registration, it'll be 7 years at least before the registration will die. So if
But
they
is it-
register,
But is it like, can they pick up like as an abandoned, or because they're not using, can they reach out to the person?
you
if
you
know who
can
owns
you
it?
can go in there and you can get the trademark registration canceled because they're not using it, but that's an extra added step.
Yeah, but
Yeah.
do people, like, I know who owns it, I figure it out. Can they reach out to the person?
Yeah, they could sell it. They could sell you their rights. But
Okay.
I mean, it better be like the greatest name on earth to spend that kind of money on it. Yeah.
Is it worth it? You saying maybe it's not worth it do you think they will just give it away, or people
No,
don't?
they're not going to give it. Nobody gives anything away. They're going to ask for money.
Okay.
Yeah.
Got it.
Okay. If we're creating an app, where does the functionality and coding fall? Which type? Good question. Okay. And okay. So a piece of software, you can get a copyright on the code itself. It's a weird standard, but you don't have to send the entirety of the code to the Copyright Office. You send just a portion of it. But remember that doesn't prevent somebody from writing their own code that has the same exact functionality. The only thing that does is prevent somebody from actually just stealing your code and having an app that does the same thing, right? So that's not that much protection. So again, a lot like fashion, where you're really going to get protection is with your branding, right? I don't just want any old app. I want an app that's made by this company because I've already bought 5 apps from them and they've worked really well. Or I know, something like that, I can't really think of that many, but there are certainly ones that do gaming and stuff, and that's the brand that you want, because you can't protect the idea. It's very unlikely that you have anything patentable in an app. And you can copyright the code, but somebody else can just write their own code to do exactly the same thing. So copyright isn't really going to help you that much. A trade secret isn't going to help you that much because everybody who uses it sees what it does. The trademark is really the only thing that you're going to be able to use. Did that answer your question? I forget who All Aces Promotion is. So
Hi.
Hi.
Yes. Yes, that definitely helps. So, so as far as a trademark itself, it's the trademark on the branding,
Right.
that you can protect pretty much.
Right. It's, blah, brand app. That's what you want to protect, is the blah.
Okay, thank you.
Okay. Any other questions on the 4 types before we kind of talk about how much does it cost and how long do they last and stuff? Okay, cool. Top 3 risks. I think I kind of covered those in the last slide. You want to go back a second, Beth, and we'll hit those again? Is that what you mean, like the risks on IP? The risks on IP are that you don't protect it properly so other people can take it from you, or that you're inadvertently or purposefully using somebody else's intellectual property without the right to do so, or that you, like when you get an independent contractor to create something for you, you don't get the rights. Is that what you meant? Okay, great. Okay, so patents, like I said, are very expensive. It's like $10,000 to $30,000 to get a patent, and it costs like millions, at least $100,000, maybe $1 million to defend it. It's really expensive, right? You hear about these gigantic patent fights, they're very expensive. Copyright, it costs, again, they've changed the pricing within the last couple of months. I think it's $35, it might be up to $50. It's not a lot of money unless, again, you're doing a ton of them. The cost to defend it, it almost never requires litigation. So really, you know, you need to pay a lawyer to write a cease and desist letter or two. Trade secret, the cost is just to implement the security measures, you know, to make sure, and, you know, to write down what your procedures are and make sure that everybody gets trained in what those procedures are and that you actually implement those procedures by having, you know, a part of the server that has all the company documents on it, you know, protected by password and things like that. And it is very expensive and very difficult to litigate, just because you have to, there's so much you have to prove. And the remedies are almost never adequate, right? Once your secret is out there, you know, you're never going to get enough money to make it all better. Trademark, it exists on its own. The cost to register, the filing fees are about $275 per class, and a class are these very arcane, ridiculous divisions of things that makes no sense. And the attorney's fees are going to be, my lowest cost package is $249, and the one that's like totally full service is about $1,000. So not as expensive as patent, but more expensive than copyright. The cost to defend, I will tell you that in 25 years of writing and receiving cease and desist letters, I have literally never had one go to litigation. You just work it out, right? It's obvious what the answer is and you just work it out. Sometimes my clients have had to give the other side $10,000 or so to rebrand. Sometimes I've gotten $10,000 for my client for them to rebrand, but it's really just a question of just working out a deal. There are a couple of times I've had to hire a litigator. I've had to have my client hire a litigator, but we've never actually gone to litigation. So, you know, those are the different things there. You want to flip over to the next slide, Beth? How long does it take? A patent, it takes more than a year. A utility patent lasts 20 years. A design patent lasts 15 years, and then your exclusive rights are gone. Copyright, this says a few months. Lately, the Copyright Office is way behind, and it's now up to over a year. It lasts for your life plus 70 years. If it's owned by a company, that's a little bit different. Trade secrets, there's no protection that you register for, and it lasts until it stops being a secret. A trademark takes 9 to 12 months for a use application and 9 to 36 months for an intent to use application. And it lasts forever as long as you're using it. You do have to maintain the registrations by paying money every 10 years, but you know, there are trademark applications in the United States that are from the 19th century, like 1885, I think is the oldest one that's out there. So yeah, so that's good. Next slide. Questions. So that's it. Any other questions that we haven't hit upon? Is there something that I should have made clearer or should have gone into deeper? What do people got? I'm going to bring up the chat box so that I can see when that happens.
This is Beth. I just wanted to say thank you for answering my question. I'm quite relieved.
Okay.
And I feel really good about it. But something that, I guess this might not be a fair question to ask you, but I'm concerned that maybe my clients don't know that the work that I do,
Yeah,
I own and they have a license for,
yep.
like, I should probably add that to my contract.
Yeah, so here's the way that I add that to the contract to make that super duper clear. What I do is I price out the cost to get those rights, right? So I say in the contract, right, this is what you get. If on the other hand, you want full rights to the underlying intellectual property, you have to pay me an additional X dollars. Right? That does two things. It brings it to their attention in a much better way, right? Because it just looks more obvious when you say, this is how much it would cost for you to get that. Then you know, then it's hard for them to say, I didn't know I wasn't getting it, because it's really obvious. And the other thing is that if you ever have to write them a cease or desist letter because you find out that they are doing what they're not allowed to do, or if you ever have to sue them, you've now established what it's worth.
I love that. That's genius. And I actually think that most of my clients are, I'm so sorry. Most of my clients are corporations who
Right.
have existing events teams. So
Right.
I'm sure that that wouldn't be of any concern for them.
Right, and it gives you an opportunity to upsell as well.
Yeah.
So that,
This
yeah,
is so fabulous.
yeah,
we
that's
have
the way I
another-
like to handle it. Yep, go ahead.
We have another question from Alexis that she says, can you show how we should add the actual copyright to written work? And do we add it to every page?
Okay, so I'm gonna type in right here into the, so if I type, I'm typing paren, C paren, but you guys know what I mean with the C in the circle. And that's a character, like you can usually pull that down in almost everything. So 2020, Verdinas Law, PC, right? So does everybody see that in the chat box? Right? You don't need to put it on every page. I did have a client and they created workbooks. They were like a tutoring company. And they actually did put it on every page because they had so many instances where people were stealing their stuff that by having that on every page, it just really drove the point home. With the date, you have to update to date every year. You only update it if you've updated the work, right? So I have like workshop papers that I've written that I wrote in 2018, like my website gets updated, right? So my website probably says copyright 2015-2020 Verdinas Law PC, right? But no, you only add more dates if you're continuing to update. But if it's a fixed document, right? I mean, the Harry Potter books, right? They aren't changing, right? So they're copyright whenever it was that they were published. Okay. I feel like I was talking about something else and then got sidetracked. Oh well, whatever. It probably wasn't important. What else do people need to know? What else would be useful?
Hi, this is Liz.
Yeah.
This was phenomenal, super helpful. So I think one of the reasons why I've been so hesitant to pull the trigger on really copywriting or trademarking anything is because I feel like once I do one, I feel like I have to do everything. Like, is it the business name? Is it the program? Is it the framework? Is it, and it just feels like millions of dollars in protecting things and I'm flying under the radar. So it's kind of fine.
Right. So there's two answers to that question. First of all, like I said, you have trademark rights as soon as you start to use a trademark to sell stuff, right? So you have trademark rights. So the question is, which of those are you going to bother to register? Even, right, I'm me, I do this myself, but all right, I only have 2 trademark registrations. I have one for the name Beeline in no particular font, even though Railway is my font and I use it. I just did it in no font and my B. Okay, that's it. That's all I've registered. I have a tagline. I have other stuff. Not worth it. Didn't bother. So 2 of them. That's all I did. And I did those separate. Whoops.
Nope, that's good. Now we've got gallery view. We can see everybody.
Okay, cool. I lost everybody. Hang on. Whatever. I'm just going to keep talking. The other question though is, the danger is if you're using something, part of the process of getting a registration is checking to make sure that you're not infringing on anybody else's rights,
Right.
right? So by not going through that process, you don't know for sure whether you're infringing on somebody else's rights. The other thing that registration gets you, it gets you what are called, it gets you all kinds of evidentiary presumptions, right? So if you have a registered trademark, you don't have to prove that you have rights. Somebody else has to prove that you don't.
Got it.
And I know that doesn't sound like a big deal, but it is.
It is.
Yeah, if I'm writing a cease and desist letter, first of all, a lot of people don't even realize that there is such a thing as common law trademark rights. So when I write a cease and desist letter and I say, my client has common law trademark rights, blah, 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 it's like taking a toothpick and like poking somebody gently, like on their shoulder. If you have a registration, it's more like hitting somebody upside the head with a baseball bat. It's just a bigger stick. So again, you have to pick and choose. You have to decide which of those things, if you had to stop using it, how bad would you feel, right? How much is it going to cost you in money to rebrand? How much of your goodwill are you going to lose, right? I mean, those are the things you have to take into account.
Yeah, like the specific situation I'm thinking of is I created a pilot program a year ago that has really taken off and is now my flagship program called the School for Entrepreneurs. And it was just because I teach sales and it's going to be like a school kind of a thing. And it just came out of my mouth. And then that's what we've been calling it since. Once it kind of took off, someone else brought to my attention, and the domain was available. So I was like, sweet, it's mine now. Once it took off, someone else brought to my attention that there's a woman named Kendrick Shope who has Sales School as her signature program. So I was like, it just doesn't feel right to me. And I'm early enough in where I'm like, all right, I'm fine to rebrand it. Unless I could have Sales School for Entrepreneurs as my thing.
Sales School for Entrepreneurs is not a trademark.
Okay.
It is a generic description of what it is.
Cool.
Right? You can't have Apple brand apples. You can have Apple brand computers. So she isn't going to make you stop, but you aren't going to make her stop. And somebody can use pretty much the exact same thing and you're never going to make them stop. In my opinion, Beth, can you put that back up a second? Can you bring the screen back up? Because there's actually a slide in there.
Which slide?
Go all the way to the bottom. There's actually like 3 slides after the question slide where I had slides that I thought I might need to answer your questions.
Yay!
Got it. Okay.
Yeah.
Okay.
Okay, so there's a chart with all kinds of pretty colors.
Yeah, sorry, I'm just.
Okay, it's okay. Yeah,
there we go.
Yeah.
Sorry, the avoiding IP mistakes.
No, there's a chart and it has like lines on it, like a graph.
Oh, okay, yeah. All right, let me share my screen.
So the answer, right? So that's the answer. The answer is you don't have anything to protect there. Okay, so here we go. So what you have is right. So if you have it's descriptive like Radio Shack, right? So you might have some value, but that value is actually going to go down over time because you're just describing what it is, right? What you want is something suggestive, arbitrary, or fanciful that grows. And then when I say Radio Shack, I mean that sincerely. It's what I call the Radio Shack problem. So it is the Sales School for Entrepreneurs. You can't leverage that to do anything else.
Correct.
Right. If you want to start now teaching them something other than sales, you can't use that brand.
So if I went to the other thing I'm toying with in the background is the Empowerment Action Club, which I'm really focused on.
Yeah, those are better words, right? Still not great. My guess is that's going to be more like Office Depot, right? It's like everybody uses that. I don't distinguish between Office Depot and Office Max. On the other hand, Staples, that I distinguish. Right? So you want to have a brand that sticks in people's heads so that when you go out to them, because you've created another program, they come back to you because they remember the first program. And using descriptive and generic words, that doesn't stick with people.
As the business name or program name?
Your brand, okay? So this is my brand, Beeline is my brand. The name of my business is Verdinas Law PC. Nobody ever hears that because who
Okay.
cares, right?
Right.
But people remember my B. People remember the word beeline. And that's what it is. It doesn't say anything about trademark, right? It doesn't say anything about intellectual property. It doesn't say anything about anything. It just tells you I'm going to get you from point A to point B as quickly as I can.
Because like my hashtag is always holy shift with the
Right.
up.
Right. Okay. But yeah, so that's suggestive, arbitrary, or fanciful, right? Like nest.
Okay.
Nest is great. So that's what you want. That's the sweet spot where strength in legal stuff meets strength in marketing.
Groovy. All right.
Yep.
So within your wheelhouse of services, is that I go to someone branding first to figure that out? Is that something
Right.
you?
I don't come up with the brands. Yeah, I'm not that person. I just help you make sure that you can use it and help you protect it.
Okay.
Okay.
Groovy.
Okay, so I'm looking through here. Okay, Liz, I think she said something's updated. Do you update? Okay, incorporate the name of new business and purchase it. Okay, no. It is possible that their domain name is available, but the trademark using those same words is not available. It is possible that the domain name is not available and the trademark is. You can get false positives and false negatives, because the standard for domain names is somebody using that exact combination of letters and numbers. And the standard for trademarks is whether it's confusingly similar. So, right, you know, yeah, somebody spells it differently, or it's just similar, right? It doesn't even have to be the same. It can just be similar, right? Like, I don't think you could get away with naming, if you started to make running shoes and you wanted to call them Mikey, I don't think you could do that, right? So domain name, the fact that the domain name is available tells me nothing. It's useless information to me. Okay, conversation about a business idea takes place during work hours between coworkers with nothing produced during the work hours. Is any part of that? Yes, so when you say coworkers, I'm talking about employees, not contractors, employees. Yes, if that idea has to do with the business that you're in, right? Then yes, the answer is yes.
What if it doesn't? What if it's just, you know, you're working for a company and you talk about a completely other different business idea?
Then it doesn't belong to them. It doesn't belong to them. If you work for a software company and you come up with a great idea for a restaurant during work hours and you talk about it with one of your coworkers, it doesn't belong to them.
Okay, great.
Yeah. Other questions? Okay, I'm going to type my address here. Oops, I'm going to spell it right. If anybody wants an NDA or an independent contractor agreement to use, I'm happy to send you the ones that I've created. I would much rather you get yourselves protected. I hate fixing problems. I like preventing problems. So I'd rather send that to you. You have to, I won't remember it on the chat. So just literally send me an email and remind me what you want, and then I'll send it to you. Any other questions? Any other things any questions I didn't answer? Anything else you ladies would like to know?